Good evening, everyone, and welcome to this third in the series of public seminars at the Education Department in Oxford on the rights of the child. Thanks to everyone for joining us. I want to say a couple of words by way of introduction, and then I'll hand over to our chair. This session is entitled Child on the Edge, concerns the plight of children in fragile and conflict states. And we've got a tremendous lineup of speakers. I wanted to say by way of introduction that this event has been convened by Wiam Hamdan and colleagues Nika and Manoli, who were students last year on a course I taught on the implementation of the rights of children. And we were very interested in the question of how do governments and society, how well are they doing in delivering the rights of children? What are the challenges of going beyond a legal document like the United Nations Convention in actually influencing in a real way the lives and experiences of children? And Wiam and colleagues felt that my course was overly focused on some of the technical policy issues without adequate reference to the range of voices and perspectives of people in diverse contexts in the way that they experience the impact of the UNCRC. And Wiam, Nika and Manoli have kindly convened this series for us this year as an adjunct to that course, but we think also an important wider public discussion. So I particularly want to thank Wiam, Nika and Manoli for organizing these events and our wonderful speakers. This session focusing particularly on the issues of how the UNCRC plays out in context of fragility and conflict. Our chair today is Federica D'Alessandra, who I'm delighted that she has agreed to chair this debate. It's a complex topic. Federica is Deputy Director of the Blavatnik School of Government's Institute for Ethics, Law and Armed Conflict. She's also an academic affiliate at the Bonavero Institute of Human Rights, a member of the steering committee of the Oxford Network of Peace Studies, and a mentor for the Oxford Character Project. I don't like long biographies, but I'm going to read out this last element. Federica has been recognized by Forbes magazine as one of the 30 under 30 leaders with the likelihood of changing the field of law and policy over the next half century. I'm very honored that Federica could join us to chair today. And I'm now going to get out of the way and hand over to Federica, who'll introduce the session. Thank you very much.
Thank you, Professor Feinstein, for this kind of introduction. And thank you, of course, to Wiam, Nika, Manoli, and to the Department of Education for not only the opportunity to chair this important discussion on the implementation of children's rights in situation of conflict and other forms of fragility, but also really for convening this discussion and the overall seminar series, because they address such an important range of issues and questions relating to children's rights and the very concept of the child. So it's a real privilege to be here and to be sharing this next hour and a half with such a distinguished lineup of speakers. Sadly, dear colleagues, this conversation could not be any timelier. Just 2 days ago, we commemorated the International Day Against the Use of Children in Conflict. And that is because children remain among the principal victims of war. And in fact, they also account for half of the world's forcibly displaced population. The harm that is inflicted on them in conflict and other situations of fragility and violence is egregious, and their suffering takes many forms. On the more extreme end of the spectrums, of course, children might be directly or indirectly targeted in discriminate or indiscriminate attacks that prey on their unique vulnerability. And it is for this reason that the UN Secretary General has identified 6 grave violations against children in war on the basis precisely of their particularly egregious nature and the severity of their consequences. These are killing and maiming of children in war, the recruitment and abuse of child soldiers, attacks on schools and hospitals, rape and other forms of sexual violence, child abductions, and of course, the increasingly the denial of humanitarian help. Each one of these 6 grave violations constitutes a breach of international human rights law and of humanitarian law, and under specific circumstances might also amount to international crimes. And yet, in 2019 alone, more than 25,000 of these violations were verified by various UN entities in at least 19 different countries. Even when children are not targeted directly or indirectly, long-term exposure to conflict, insecurity, and violence will have a destructive impact on their overall well-being, development, and mental health. In war, children might experience, of course, multiple and accumulated assaults, but war also disrupts the child's social networks and primary support relationships, including family and schools and their communities. The right to health, education, life, and development are all affected, not, of course, to mention the trauma that they suffer, with very profound physical, emotional, and psychological implications. Implications which, by the way, not only affect the child, but affect society as a whole. Because it is a sad and horrifying reality that many of today's conflicts last an entire length of a childhood, meaning that from birth to adulthood, many children today will know no other reality than war. And in fact, in some of the long-standing conflicts, entire generations have never known a single day of peace. So children, of course, benefit of protections under international law. And as Professor Feinstein was just saying, the UN Convention on the Rights of the Child is the primary international legal instrument that is concerned with the protection of the human rights. But equally, other bodies of international law, as I just mentioned, humanitarian law and international criminal law, among others, recognize this need for protection. And however, even though preventing, monitoring, and responding to violations of children's rights in conflict has formed part of the UN Peace and Security agenda for over 2 decades, their plight continues not to receive adequate attention. Importantly, violations against them are often perpetrated with impunity. A study that our institute recently published with Save the Children highlighted a number of structural, attitudinal, and political challenges to upholding accountability for violations and crimes against children. As I think one important aspect of this conversation is that it is intended to bring to the fore other voices. And this is extremely important because one of the results of our study was that children in conflict are often unseen. For our attention is oftentimes focused on the wartime experience of adults. And even when they're seen, children's wartime experiences is often unsituated, meaning that it doesn't account for the diversity of what they experience based on factors like their age and gender and other factors, such as, for example, disability. We just don't disaggregate data reflecting these various experiences enough. And of course, this affects our ability to uphold states' obligations and hold them to account. And a lack of accountability for these violations will weaken the rule of law, will undermine the prospect of long-term peace and stability. And it is power imbalances and asymmetries that are often the chief culprit in this picture of impunity. So much thinking, research, and advocacy still needs to go and is necessary to overcome this dire situation. And it is for this reason that I'm particularly grateful to the conveners of this discussion to setting us on the path to have precisely this conversation. So in the course of the next 90 or so minutes, we'll have the benefit of our panelists' enormous insight to try and better understand some of these issues. We will first hear from Professor Jacqueline Bapam, one of the foremost experts in this field. She's professor of practice of health and human rights at the Harvard T.H. Chan School of Public Health. She's director of research at the Harvard FXB Center for Health and Human Rights, the Jeremiah Smith Jr. Lecturer in Law at the Harvard Law School, and also an adjunct lecturer in public policy at the Harvard Kennedy School. And I believe Professor Baba will open our discussion with her perspective on how power imbalances and asymmetries affect the implementation of children's rights, particularly in volatile situations such as armed conflict. We will then hear from Ambassador Omar Awadallah, who's Assistant Minister for United Nations and other specialized agencies with the Ministry of Foreign Affairs of Palestine, who will speak from a policy perspective about both the benefits and the challenges of using an international framework, such as the UN Convention on the Rights of the Child, in realizing the rights of Palestinian children. I apologize, the lights have just gone off in my office. My sincere apologies for that. I hope that everybody can, if not see me, at least hear me clearly still. And after we hear from the ambassador, we will turn to Mirza Sahib, who's a human rights advocate, and I am proud to say also an alumnus of the Blavatnik School of Government, I believe MPP class of 2020, who will speak about how the conflict in his home region of Kashmir affects children's right to education in particular. So it goes without saying that I'm looking very much forward to every one of our speakers' insights. They will speak for around 15 minutes each, in the order that I've listed them, and then we will open the floor for discussion with the audience for a Q&A of about 30 or 45 minutes. So please be sure to participate. You can pop your questions in the chat box, and I look forward to the discussion. And now, that being said, I want to thank again the speakers, the organizers, and everyone in attendance today. And without further ado, I'll turn to Professor Baba to open our discussion. Thank you so much.
Thank you very much, Federica, and thank you very much to Professor Feinstein and to Minoli, Weam, and Nika for this event. I couldn't agree more that it's really essential to talk about the implications of the situation of children who are trapped in conflict when we're talking more generally about the rights of the child. And I commend Professor Feinstein for learning from his students, as we all do, and you know, moving on from his lectures to something like this, which is interdisciplinary and multifaceted. So I thought that what I would do is actually try to contribute some general comments about why it's so hard to move from the reality of law to implementation on the ground in these areas. Because it's, as a human rights lawyer, it's one of the kind of ongoing stressors in a way of our lives that we spend so much effort perfecting the law, getting states to ratify international laws, and yet we find the enduring impact often doesn't really give us much to show for. So I just wanted to start with some of these more general reflections, which I think are very relevant to our topic. So first of all, obviously, it's a truism to say that drafting and passing legislation, on the one hand, is necessary, but on the other hand, not sufficient for changing the circumstances of those affected by law. And this is true of human rights law and international human rights law. It's true of the Convention on the Rights of the Child, or the UN Refugee Convention, or the Geneva Conventions, or any other body of international human rights law, just as much as it's true of domestic legislation. And I think this is an important point, that whether we're talking about taxation or protecting consumers when they buy products, we need to think about the political will that generated the legislation and why that political will so often evaporates or dissipates when it comes to implementation. And I think the first point here is that the human resources, the financial resources, the political clout, the cultural clout that we often manage to harness to make legislation somehow is no longer at the focus of our attention when it comes to concretizing the commitments that states have willingly taken on. So from my field of work, which is refugee protection, consider this situation where in many countries, the processing of asylum claims takes years, sometimes even decades, not because the cases are inherently so complex that people are poring over them for years and years, but because there's a willful shortage of staff, because governments decide not to allocate the necessary resources to enable people to have their asylum cases dealt with expeditiously. And imagine if there was that same attitude to processing business visas or other urgent kind of aspects of state practice. This disparity, I think, is really a clear illustration of the point that I think Federica already made about asymmetries of power and asymmetries of political leverage. So as we think about implementing the rights of the child, particularly in adverse situations, I think all of us as activists of one sort or another need to be thinking about the political tools that we use to get these laws on the books and think about ways in which we can sustain those political processes further on. A second truism is, of course, that some constituencies have much more political clout than others. So to state the obvious, citizens who vote have more power than stateless people or undocumented migrants or even lawful permanent residents who don't vote. Similarly, and relevant to our topic today, adults who vote have more power than children who don't vote. And similarly, maybe at a slightly lower level of generality, those who are politically organized, those who have the ability to lobby, often but not always correlated with money, for reasons of wealth or race or gender or social network, they also have much more political clout. And I think as Black Lives Matter or Me Too or movements which highlight the enduring impact of settler colonialism have illustrated, these legacies of power endure. And they endure and they permeate the ability to move from the theory of law to the practice of rights implementation. So to summarize these initial points, some constituencies are ab initio multiply disadvantaged. And there are some that really fall within that section of the Venn diagram where many of these different factors of exclusion overlap, whether for historical reasons or political reasons or reasons of our enduring cultural biases. And children, including non-citizen children, children living under occupation, children who are stateless, children born to families who lack relevant political networks are absolutely a case in point. They are often at this dangerous point of confluence of different elements of the Venn diagram. And so here it is that we are in the situation that we're talking about, in which we have, I think, some great colleagues who are going to talk specifically about particular struggles. Here we are in the situation in which this mismatch between the theory of law and the practice on the ground is so evident. But I don't want to just spell doom and gloom, because we do have a range of tools, of course, powerful tools, which have been utilized over time to address these inequities, and which we can continue to use and to make a difference with. So let me say a little bit about that as we consider ways in which the tools that we have available, the legal tools, the advocacy tools, the networking tools, the convening tools, as we think about how these can contribute. So firstly, just to take the law, since I'm a lawyer and others of you may be lawyers, and we're talking about a legal framework. Law does provide very powerful tools, even after we have legislation on the books, to advance a struggle. And one of the most powerful tools, of course, is taking a case. So choosing a case as a test case, choosing a case as a class action case or as a public interest litigation case if you're in India, choosing a case which will affect ongoing practice, not just for the applicant of the case, but for a whole class of people who are affected. And so we have some really excellent examples of this sort of use of strategy, of legal strategy, as a part of as part of the toolkit of an advocacy movement. So the exclusion of children from access to protection, for example, by adverse migration contexts, or the use of detention against children who are in conflict with the law or children without status, or the exclusion of children from school because they lack a legal status or they have the right citizenship. All these types of human rights violations have, in specific cases, been successfully challenged. So I think the first takeaway here is that working with one's constituency, including one's constituency of children, to manipulate the law in a way that it can deliver success is a very important strategy, which probably we underutilize, partly because we don't have adequate resources, but also partly, I think, because we aren't thinking often strategically enough about how, something like Article 3 of the Convention on the Rights of the Child, which talks about the best interests of the child, or Article 8 of the European Convention on Human Rights, which talks about the imperative of protecting the right to respect for family life, or Article 33 of the Refugee Convention, which talks about non-refoulement. All these instruments can be used again and again to advance an advocacy strategy, even when the law on its own is not delivering. Secondly, I think legal tools can be very useful as part of a, if you like, naming and shaming strategy against states. And I think this happens again and again in the context that we're talking about. So if you're talking about children under occupation in Palestine, and I'm sure our colleague will mention this, if you're talking about Syrian and Afghan refugee children in Europe, in Greece, in refugee camps, still after years denied access to mental health support, or you're talking about Rohingya children in refugee camps in Bangladesh who are denied access to the domestic schools and actually denied access to education. These kind of ways of showing the mismatch between what states have voluntarily agreed to sign on to on the one hand, and what in practice they're still tolerating or even enabling, I think these strategies can be important and sometimes useful and even productive. So I think, for example, to give an example, recently, I think the amount of attention that has been given to, and Federica mentioned this question of stress and the enduring trauma that children in conflict or under occupation face, the increasing awareness that this trauma is not short-lived, but can actually have lifelong consequences and also can be irreversible, as now we know from the work of scientists and of neuroscientists and so on. We know that toxic stress endured in early childhood can have very lasting effects. So the increasing knowledge about this and the shaming in a way of states like EU member states of failing to make resources available, I think has made some difference. It has, to some extent, pushed the needle. So that's the second way in which using the law can make a difference. And thirdly, I think there is a practical way in which human rights lawyers can work with child rights groups to actually, in specific cases, challenge harm or challenge human rights violations. So for example, I recently was speaking to colleagues working on issues of statelessness of African children who are migrating with their parents and born outside their country of origin, who fall between the various stools of nationality allocation. They're challenging that in a particular EU member state as a clear violation of the obligations of that country with respect to those children. A couple of more general comments. I think that the laws we have and the constituencies that we are all part of enable us to build not just domestic coalitions, but international coalitions, because we're affected by similar factors. So apart from the US, of course, famously, every other member state of the United Nations has ratified the CRC. So we all in these different member states have similar cases to be made, and we can build coalitions similarly on detention, similarly on children affected by armed conflict. Many different legal provisions apply across the board. So whether you're talking about Sri Lanka, or whether you're talking about Colombia or Sierra Leone or Kashmir, there are commonalities here which can enable us to join forces. So that's one general point. The second general point is, I think, the increasing awareness of the essential role of children themselves. Children themselves, not just as rights bearers, but as actual actors here, as sometimes leaders of these important political movements. And I think some of the countries that we're going to hear about, Palestine, for example, are obvious cases in point where Palestinian children, you know, from the first Intifada onwards have been key part of liberation struggles. Their voices have forced themselves onto the agenda. We see this more and more with Afghan girls. We see this with refugee children, that actually there's some of these teenagers in particular who are using social media, using other platforms to really leverage the power that comes with their status. So I think that's another really important point. I want to just end by making a more general observation about the current moment and the way in which the current situation with respect to children's rights and international law is changing. I think that for many decades, those of us involved in children's rights building and children's rights advocacy have really grounded our arguments and our reliance on the legal framework with reference to World War II, to the Holocaust, to genocide and fascism in Europe, and to the enduring human rights obligations that were generated as a reaction against those kind of foundational human rights harms. And that's a very important historical legacy, of course. You know, alas, genocide is still with us. We've just seen this, you know, in Myanmar. We see this, you know, I don't know, possibly in Ethiopia. There are many situations in which genocidal movements are still around and are still very powerful. So making reference to that history is important. But I think over the past years, maybe half a decade, we're also looking beyond those foundational moments of World War II, looking to the older histories of enslavement and colonization and the legacies that they continue to generate and how those affect children and other constituencies, but we're talking about children. So, for example, the way in which the history of colonization affects who gets to move and who doesn't get to move, who needs permission and multiple visas and multiple different bureaucratic hurdles to actually make a choice to seek freedom or to seek safety, and who doesn't, who can more effortlessly cross borders. These are legacies from previous era that we haven't sufficiently acknowledged. Similarly, questions about violence and what types of violence are tolerated or not tolerated, what types of violence are seen as grave human rights violations against children, reflect our enduring prejudices that come from histories of settler colonialism. And whether we're talking about Palestine, whether we're talking about indigenous people in many of the countries that we live in, there are ongoing egregious acts of violence which don't rise to the fore in the way they should, because they're somehow still part of an under-examined legacy. So to conclude, I think that as we move forward with advocates and with many of you, maybe the 3 students and others, as the next generation of people who are going to work within a child rights and a human rights movement to build this bridge between legislation and implementation, we have enormous tasks ahead. There's much that we still need to question. There's much that we still need to change. And there are many constituencies, including, of course, most importantly, children themselves, who need to become a central part of the struggle for justice. So thank you for listening. And I'm really looking forward to the contributions of the panelists and to the Q&A afterwards. Thank you.
Thank you, Professor Baba. This was such a wonderful and rich set of remarks. There's so much to follow up on, and we look forward to doing that in the Q&A. But let us right away turn to Ambassador Awadallah to hear his perspective in terms of precisely how this is playing out with regards to the Palestinian struggle. and the rights of children in Palestine.
Thank you very much. Thank you, Federica. And also I would like to extend my appreciation also to the organizers and Professor Leon and my friends and colleagues, also Wiam and Minoli and Nika, and thank you for this and having me today. Actually, and thanks for Professor Bahabha also. She has a good introduction remarks and good remarks actually about the children in armed conflict, and she tackled very important issues. I want to start by talking some little words about Nakba, the catastrophe of the Palestinian people in 1948, and this is something happened to our very famous poet Mahmoud Darwish when he was a child and his family displaced, and they went out of Palestine because of Nakba. And when he was in the camps, he was hearing the word refugee. And he was a child, 5-6 years, and he was asking his father, "Hey, Dad, what does it mean to be a refugee?" His father was talking at nothing, you will never understand. The kid went to his grandfather and asking him, "What does it mean to be a refugee?" Then his grandfather told him, "Being a refugee means that you are not a child anymore from now on." This is, we can summarize all the Palestinian problem in that. The attack on the Palestinian children is an attack on the future of the Palestinian people. That's why it was in the core of our fight to freedom and independence to protect our Palestinian people and Palestinian children, to protect our future. And if we look at the report of the Secretary General and the report on the children in armed conflict for 2021, it's really deeply alarming. This report brings to the surface the international community's mounting challenges to protect children and uphold the Convention on Rights of Children to ensure accountability for escalating violations against the affecting children. Compounded with the deadly pandemic and entire generation of children experiencing life-altering effects with grave short and long-term consequences, including and most specifically Palestinian children. The grave situation that children are facing require urgent steps to be taken by the international diplomatic community to ensure their protection and well-being without exception. Yet, against the backdrop of the United Nations Secretary General's call for a global ceasefire during the pandemic, we witnessed and continue to witness the ongoing Israeli aggression against the Palestinian people under illegal occupation and apartheid, sparing no one, including our children. For example, in 2021 alone, Israel killed over 78 children. It forcibly displaced entire families from their homes, most of whom were children. It bombed schools, hospitals, and systematically denied Palestinian children access to health care, and over 170 Palestinian children are in Israeli detention center in a violation of the basic human rights and decency and morality. In fact, the number of in Palestine are grim. UNICEF predicts that over 1,100,000 Palestinian children are in their need for humanitarian assistance. Indeed, the lives of Palestinian children practically in Gaza Strip, which is now for more than 15 years under a legal blockade, as was described by the Secretary General in his remarks in 2021, that they are in hell on earth. Palestinian children are not the invisible victims of the armed conflict. Rather, they are the visible and most targeted victims of Israel's ongoing violations and crimes and policies. In so many reports by the fact-finding missions and the missions of inquiry that visited Palestine and were established by the Human Rights Council, they concluded that the Israeli occupying power were intentionally targeting civilians and intentionally targeting children. What marks Israeli crimes committed against Palestinian children practically grave is that they constitute an integral ingredient of the widespread and systematic discriminatory and persecutory practices adopted by successive Israeli governments in furtherance of its colonial policies aiming to displace and replace the Palestinian people. On the characteristics features of these patterns of crime in their discriminatory nature since 1948, the attitude of Israeli officials at governmental level, military, police, judicial officers, with regard to the protection of the fundamental rights of all Palestinian children, whether in state of Palestine or Israel or in exile as refugees, demonstrates an approach to the treatment of Palestinian children that is entirely different from the way in which they seek to guarantee the rights of Israeli children, including as regard the protection of their life and well-being, as well as their access to justice, unfortunately. This is why we have been saying that Israel has used military rule and occupation as a key tool to establish its system of oppression and domination over Palestinian people in the state of Palestine and in Israel, in order to advance their racial regime. Israel has created and maintained an apartheid regime of systematic oppression, domination over Palestinian people, and controls virtually every aspect of Palestinian children's life, and routinely violates their human rights, as stated recently by Amnesty International, Human Rights Watch, Amnesty International, Human Rights Watch, and both Palestinian and Israeli NGOs. And here I call you and I ask of you to read the significant report coming out by Amnesty International about the apartheid in the state of Palestine that came after a rich list of reports about the system of apartheid that Israel is building in the occupied Palestinian territory. Human Rights Watch also has such a report. Israeli NGOs like Yesh Din and B'Tselem, also they published a report about the Israeli apartheid regime that is in the occupied Palestinian territory. With this in mind, the state of Palestine in its diplomatic, legal, and political endeavor has been firm in its conviction that the protection of Palestinian children is humanity's foremost moral, legal, and political obligations. Throughout this talk, I will shed light on what we did on our national and international track to protect our Palestinian people. On the national track, we acceded to so many human rights conventions because we believe that we need to be part to the international community's call to protect not only children, but all the human rights, including in the occupied Palestinian territory. So one of the first conventions that we acceded was the Convention on Right of the Child. And we acceded to all these human rights conventions without any reservation, because we want to apply all these human rights on our Palestinian people, and we want to face and to fight the impunity and the way that the Israeli occupying regime is trying to impose their illegal policies over the Palestinian people. Upon our entry, as per the commitments and obligations toward this convention, we established a national committee to harmonize our Palestinian laws in accordance with the CRC to protect our Palestinian children, at the same time in accordance with our Declaration of Independence. And we always aspired and worked toward ensuring the protection of our Palestinian children. The report details, and we submitted our report to the treaty bodies in Geneva and the Human Rights Council, and submitted this report to ensure the protection of our people and of our children. And we detailed in that report the measures, the frameworks, the policies that we took, and legislative and administrative aspects relating the provisions of this convention. I highly encourage you, if you have time, to read these reports about how we are trying to adapt and accommodate the international conventions, including the CRC in our Palestinian laws and bylaws. Most importantly, I can say that we have a very good coordination between the government of the State of Palestine and the civil society to produce these reports and to work on implementing the provisions of the CRC within the State of Palestine. And I was looking for our friend Brad from DCI Palestine. Unfortunately, they are not here today, but I was looking forward to hear also from them about this kind of coordination and cooperation about implementing the CRC in the State of Palestine. Allow me here also to bring to your attention that the latest Israeli unlawful attacks on Palestinian NGOs, Israeli systematic attacks on Palestinian civil society organizations, they are attacking these organizations and trying to enlist them as so-called terrorist organizations, trying to silence these organizations because these organizations are working on the exposure of Israel's violations against the Palestinian children and Palestinian people. The unlawful designation of DCI itself as so-called terrorist organization is not a coincidence. It means to hamper the DCI meticulous reporting on Israel's crimes against children. It is worth noting here that the committee of the CRC has over and over again regretted that Israel willfully failed to provide information on Palestinian children, adhere to the committee's many recommendations, or apply the CRC in the State of Palestine under the occupation. The committee in 2013, as far as it say that, and I want to quote here, that the illegal long-lasting occupation of Palestinian territory, the continued expansion of unlawful settlements and construction of the wall, as well as land confiscation, destruction of houses and livelihood of Palestinians, constitute severe and continuous violation of the rights of the Palestinian children and their family, feed the cycle of humiliation and violence, and jeopardize peaceful and stable future of all children in the region. This is the recommendation that came out by the CRC committee in Geneva, and they continue to put the same recommendations to Israel to fulfill its obligation as an occupying power toward the Palestinian people. On the international level, as a state whose territory remain under a foreign occupation, Palestine is subjugated to foreign policies imposed upon its citizens, including children, for the purpose of maintaining a colonial occupation. Those actions undeniably aim to displace and replace the Palestinian people, resulting in over 7 decades of forced dispossession and displacement endured by our people. You can imagine the difficulties and challenges we face as a state party to the CRC in ensuring the protection of the Palestinian children. In light of Israel's unpatted and unaccountable violations of rights of children, we redirected our policies toward international bodies to ensure deterrence, protection, and respect of these rights. Our diplomatic endeavor was based on acceding to international conventions, using the international mechanisms, using the available mechanisms for protection, for accountability, like sending letters to the Secretary General and to the Security Council, according to Resolution 1612, as you mentioned, Delisandra, before, about the children armed conflict. And we sent letters to the Secretary General to enlist Israel and its agents and its settlers as parties that are violating the rights of the Palestinian people and children in armed conflict. Unfortunately, the Secretary General failed to enlist Israeli army, occupying army, and the settlers, the terrorist settlers, into that list, while all the bodies within the United Nations, including UNICEF, including the Undersecretary General on Children in Armed Conflict, with their recommendation to list Israel as a party that violates the rights of children in armed conflict. Also, the State of Palestine acceded to the Rome Statute, to the International Criminal Court, seeking justice for the Palestinian victims and to the Palestinian people and Palestinian children. And we submitted a monthly reports to the ICC, International Criminal Court, to calling for justice, calling for accountability, because for 55 years of its occupation, Israel never gets accountable for any of its violations or of its crimes. Last year in February, the prosecutor of the International Criminal Court opened an investigation into the crimes that are committed in the occupied state of Palestine by the Israeli officials, and the investigation is ongoing now, and we are trying to submit all the papers, all the evidence that the Israeli army and all other agents are committing crimes and war crimes and crimes against humanity against the Palestinian children. I can add also that when we acceded to the Convention on Elimination all forms of racial discrimination, third convention, we submitted also a complaint to the convention asking the committee to investigate the Israeli discriminatory policy against the Palestinian people, that Israel is building a racial regime against the Palestinian people. That complaint was accepted. It passed the jurisdiction, the admissibility, and now we have a committee that is looking into the Israeli violations of the rules of this convention. All what we are trying to do in our fight to freedom and independence, to protect our people. We know that there is a huge problem by the inaction of the international community. We acceded to all these conventions. We are abide by the rules of the international community. Unfortunately, Israel is not abiding by any of these rules. We have so many resolutions within the Human Rights Council, within the General Assembly, within the Security Council. Israel is implementing zero of these resolutions. And unfortunately, the international community is not doing what they should do. Actually, all the resolutions, all the reports coming out from the international community, including the fact-finding mission, they are putting very good recommendations about what Israel should do, or what do the third parties or the other state under the universal jurisdiction they should do to protect the Palestinian people from one hand, and to get the Israelis accountable on their crimes. But the inaction of the international community, this is one of the challenges that we really face. That's why we went to the ICC trying to find justice for our Palestinian people, because the ICC, it can bring perpetrators of such crimes to justice. In all, I can tell that Israel is affecting all the aspects of the life of the Palestinian people, including the children. They are attacking education, they are attacking schools, attacking play gardens, they are attacking hospitals. Unfortunately, with no action, they have impunity and with no accountability. And we all know that impunity feeds criminality. And if you don't start the track of accountability for perpetrators of the vicious crimes, there will be no justice. Without accountability, there will be always an absence for justice. And we believe that the absence of justice in Palestine, that means an absence of justice all over the world. This is here I can stop actually. Here I can stop actually, and maybe while answering the question, we will find the way how to minimize the gap altogether between the inaction of the international community and what is the international conventions are talking about, and how to implement the international conventions for the sake of children, for the sake of human rights. Thank you very much.
Thank you, Ambassador, for your perspective on these issues, and for really drawing out the full spectrum of international legal instruments that can be brought to the fore to bear on the implementation of children's rights. I think you raised a very important issue, which is that of accountability for criminal conduct and international crimes. I think this is particularly important for our discussion because, as I mentioned earlier, I think not only some of these violations may amount to crimes under international law, but also, and perhaps we can pick this up in the discussion, human rights law imposes duties on states. So if human rights law conceives of states as duty bearers, where does it leave us in terms of the role of non-state actors and violence that they afflict on children and the role that they play in the violations of children's rights? So I think that's where international criminal law has an important role to play. And I look forward to picking this up in the Q&A. But first, let's turn to Mirza for his perspective, shifting our focus on a different conflict and the situation in Kashmir, and I believe specifically the subset of rights that concern children's education. So Mirza, the floor is all yours.
Thank you for having me. I'll just share my screen for a presentation, which might make it easy to follow the maps and different points that I'll be making. So please let me know if you can see the screen, and I'll start. So I'm starting with this map of undivided Jammu and Kashmir to contextualize where we are and provide some background. The map that you see in front of you right now is not a map that we see in our schools in Kashmir while growing up, because this map shows the areas of political control by India, Pakistan, and China. And almost all schools in Kashmir will, in fact, every school in Kashmir would show this territory as completely controlled by the territory of Kashmir, which controls that region. For example, if you are in Indian administered Kashmir, you will see all of this as controlled by India, as a part of India. And on the left-hand side, the part which borders Pakistan and Afghanistan is the part that is shown in Pakistani schools as completely part of Pakistan, as well as the central part, which is controlled by India. Pakistan does not make claims to the right-hand top corner, which is controlled by China. Now, Kashmir is one of the most densely militarized places in the world, and it is the site of multiple wars between India and Pakistan. It is also the site where egregious violence is wrought upon the civilian population. And while it is difficult to state with certainty the exact number of soldiers present there, but at any given point of time, the number is over 400,000, rising up to 600,000 at some points of time. So naturally, all children in Kashmir grow up as witnesses to the war around us. We go about our daily lives while a passive and undeclared war is raging in our backyards, in our gardens, our schools, our hospitals. And Kashmiri children living in the occupied regions are routinely denied their right to life, their right to education, they're denied access to proper healthcare, and among other rights denials, which are inherent in a decades-long military occupation with no end in sight. Additionally, there is a complex, inadequate, and sometimes outdated legal system which perpetuates rights violations, all at the same time, while the state machinery engineers a cognitive dissonance to prevent any truth from coming out. In fact, this map that I showed you is a part of that cognitive dissonance, because showcasing the regions that are not controlled by India is offensive within the Indian territory. So I'll move on with this to just give you a brief overview of what I'll be discussing. And over the next few minutes, I'll be touching upon the various impediments to education and a safe childhood in Kashmir, the internet blockades by the Indian government, dehumanization of Kashmiris in general and Kashmiri children in particular, closure and burning of schools, and the use of law to deny rights and suppress rights as opposed to liberating people. So right now, as we speak, 3 million Kashmiri children are facing a continued onslaught on their education due to reckless policies being employed in Kashmir. India leads the world in internet blockades, and these are most devastatingly imposed in Kashmir for many months on end. There is often a suspension of all communication, phones, internet, and even letters. And I don't mean communication just in the human sense of the term of communication, but I mean every activity that can take place on the internet: banking, hospital records, online schooling, work from home. Everything comes to a grinding halt when the internet is suspended in Kashmir. The state has worked consistently in Kashmir as well as in India to engineer a cognitive dissonance so that observers will disregard their perceptions in favor of the officially dictated version of events, leaving the narrative completely dependent on the state's definition of reality itself. And any dissent against the state's version of reality is brutally suppressed with arbitrary detentions and even anti-terror legislations. At the same time, we see an overwhelming majority of the Indian electorate approving the brutal policies that are used to govern Kashmir, either by vocal acceptance of these policies or by a conspicuous silence. Kashmir is a conflict zone, and it has been undergoing a liberation struggle that dates back to nearly a century now. But the Indian government wants to convey that India has undergone modernization and is therefore qualified for democratic deliberation on behalf of the Kashmiris, who are painted as supposedly regressive people and unfit for self-governance. Now, this discourse is on the verge of articulating a differential value of lives of Kashmiris. And therefore, there is no great public outcry in Indian society when there is dehumanization of Kashmiris. In fact, the normalization and approval for dehumanization of Kashmiris is reflected in this small example over here. Just one example out of the many that can be found online and any reports on Kashmir from 2017, where a young Kashmiri man was tied to a vehicle by the Indian Army and used as a human shield. And soon after this, there were promotional T-shirts made and sold by Delhi's BJP spokesperson. BJP is the current ruling party in India. They were sold online on a shopping site run by his company, celebrating the use of a human shield, flouting all human rights, and considering this dehumanizing action to be patriotic. So in addition to this, this is the environment in which we are speaking about children's education and their rights. But in addition to the general dehumanization and the violations of human rights, there are consistent interruptions to education which are engineered by reckless policies. The Universal Declaration of Human Rights declares that childhood is entitled to special care and assistance. And this is affirmed by the United Nations Convention on Rights of Child, which specifies and details international standards for children's rights. And India has ratified the CRC in 1992, but its implementation, and in fact, as was mentioned earlier in the discussion, that the laws can be very beautifully framed and very well worded, but their implementation is conspicuous by their absence, and especially in Kashmir. Violence permeates all parts of life, and children living here suffer from significant mental health disorders with acute levels of post-traumatic stress. There are frequent disruptions to formal schooling. There are limited opportunities to socialize and erratic schedules which are leading to a rise in depression and behavioral issues among children. Since 1990, Kashmir has lost significant number of working days due to conflict. Every year, schools get shut for a prolonged period because the most number of shutdowns have taken place in a few years that I've highlighted here. 207 working days were lost in 1991, 112 were lost in 2010, and so on. And this accounts for nearly 40 to 60% of the year which is being lost, and children don't attend school in this period. And the impact of militarization has been so profound and so deep on the educational atmosphere in Kashmir that the Economic Survey Report of 2017, which was released by the Chief Economic Advisor of India, it accepted that due to 130 days of forced closures of schools in 2016, students from class 1 to class 9 had been given a mass promotion without any exams. Because after each incident of disturbance in Kashmir, schools and colleges are forced to shut for many months, and many students are taught less than 50% of the curriculum of that year. These students then compete in national exams against Indian students who have no history of dealing with these kind of hurdles that a Kashmiri student has to endure. And there is no policy in place, there is no legislation in place to bring the Kashmiri students at par with other students against whom they are competing, the other students who have had a more conventional year without conflict. And even in the context of non-conflict regions, there are multiple studies that show that there's a decline in achievement on returning to the classroom after a long break. Breaks in education that are faced by the children in Kashmir are unpredictable. They are surrounded by fear, trauma, and all these factors are severely detrimental for learning and development, and it is unsettling for students, making it tougher for them to reorient themselves into regular schooling routine. This is especially precarious for younger children because at a formative stage, a young child's brain is building their neural connections at an intense rate. And that can be so badly affected by fear that their normal cognitive development is undermined. In addition to the general conflict that is going on in Kashmir, schools are often overtaken by the armed forces. A 2008 survey revealed that nearly 650 school structures had been razed, and many schools had been overtaken by the security forces to set up camps over there. In some cases, schooling continued in those schools along with a heavy military presence inside the school. which turns the site of education into a heavily militarized space. It's a space of intimidation where students do not feel safe and free to express themselves as one would expect in an educational environment. In 2016, the border security forces, which are India's armed wing for the border regions of India, they set up camps in schools when there were mass civilian protests in Kashmir for over 2 months. And India's central government deployed about 2,600 soldiers inside the valley who were then stationed in educational institutions. So in addition to the overall conflict, which is connected to political turmoil, there are also natural disasters that have caused severe impediments, such as floods in 2014 and earthquakes. The floods had left about 6,000 schools in ruins, and almost all the affected schools had lost their vital infrastructure, including office records, computers, furnishing, and the government asked students to resume classwork despite the lack of proper transport, clean drinking water, electricity, hygienic conditions, and other basic facilities. But more importantly, there were teachers, support staff, and students who had lost their homes and they had to live in makeshift shelters at that point of time. So the policies of the government failed to take into account the psychological impact of what these children were going through. And this is because violence is so normalized in Kashmiri society that the policies that are being made are not factoring in the psychological impact of living in that place and devising policies that would address the needs of students over there. There are also a lot of attacks that have taken place on schools. There have been attacks on school children, on faculty members, as well as on school buildings. Until recently, in fact, there was no protection given to juveniles in Kashmir. And children who were arrested from protests, and because there are often protests that break out against the government in Kashmir, the children who were arrested in these protests would routinely get jailed alongside criminals. And even after juvenile justice legislation has been passed, there are still extrajudicial methods which are employed to circumvent the law, to detain, arrest, and harm children psychologically as well as physically. In fact, in 2017, in April, 50 students had been shot with pellet guns when hundreds of students led a protest against Indian armed forces in Srinagar, to the capital of Kashmir. And these pellet guns are like shotguns which fire multiple tiny pellets at the same time. Oftentimes these pellets, these metal balls, they get lodged into the eye sockets of the victim and they can result in permanent blindness. And I struggle to find a parallel example in the modern world where a democratic government has used such force against children, which has led to permanent blindness because they protested against the government. But there have been numerous attacks on schools in Kashmir. In 2014, heavy artillery shelling by soldiers forced 120 government schools to shut down. It caused heightened levels of fear, distress for local communities. And the paramilitary forces are routinely accused of directing tear gas shells into schools and hospitals. In addition, there have also been attacks of arson on schools and government buildings. And the government is unable to identify who is perpetrating the attacks. In 2016 alone, there were 32 buildings, school buildings, which were burned down by unknown people. So, and amidst all of this, any sense of justice from the civil society of India is elusive in light of sweeping assumptions of integrity and honor on part of the Indian security forces who are stationed in Kashmir. I will move to the last section of my conversation, my talk over here, which is on the laws that are used to suppress any kind of dissent in Kashmir, any kind of challenge to the government policy or the government narration of events. And most importantly, the laws that are frequently deployed are laws of sedition, UAPA and PSA. UAPA is the Unlawful Activities Prevention Act. It is an anti-terror legislation which functions as preventive detention as well. And the Public Safety Act is specifically a law of preventive detention under which human rights activists, journalists, lawyers, anyone who has spoken against the government's version of events have been detained. The UAPA has even been imposed on people for using the internet and for many arbitrary things. So essentially, it is a law which is being used very recklessly. And very quickly, I can point out just a few examples of how this law has been utilized. But before I move there, I would like to point out that often in the international audience that follows India, sometimes people make the assumption that things went bad after Prime Minister Modi came to power. But even in previous governments, and especially from a Kashmiri perspective, there is little difference between the Congress government and the BJP government. Although under the BJP, there's a heightened sense of barbarism and dehumanization, Islamophobia, and other policies. Even right now, even just today, there are bans on hijabs and on face veils being imposed in southern states of India, and Muslim females who are entering educational institutions are being forced to remove their face veils, their hijabs, before they enter the educational institution. I was mentioning that the UAPA had been imposed on people for accessing the internet, because 2 years ago, in 2019, when the Indian government had amended Article 370 and revoked the autonomy of Kashmir, at that time, there was a 6-month-long internet shutdown in Kashmir. All communication on the internet had been crippled for 6 months. Eventually, the government allowed access to just about 300 websites. And at a time when Kashmir did not even have a 2G functioning speed, and for those who don't understand 2G, you can barely upload a photo using a 2G speed. You might just be able to communicate on text on those speeds. At that time, ironically, the Indian government gave us access to Netflix and Amazon Prime, but we had no access to social media. And some people tried to use virtual private networks, VPNs, to circumvent the ban and upload information about what was happening on the ground, because all journalists had been gagged. Anyone writing anything against the government was being charged under the UAPA, which I repeat is an anti-terror legislation. In some cases, people who were sharing photos that have already been published previously with international media outlets like Washington Post, New York Times, the BBC, they were also charged under the UAPA. So at that time, the government passed a blanket order charging anyone under the UAPA, under an anti-terror legislation, if they have accessed social media. So the mens rea or the actus reus, which is essential in any crime, it didn't matter. It didn't matter whether you accessed social media to post an update about your friends or about you being alive. So your family living outside India, outside Kashmir, would know you're fine. It didn't matter. The very act of accessing social media was being charged under an anti-terror legislation. And I'll just quickly make this one final point about how these preventive detention laws are being used in an arbitrary manner. And the idea of these laws is often just to govern through incarceration. So incarceration seems to have become an instrument of state policy for governance within these regions. And recently, a Right to Information Act application revealed that nearly 90% of the inmates in Jammu and Kashmir are under trial prisoners, which means that these are not people who have been convicted. They are just facing trial. And less than 2% of individuals who had been arrested in connection with the armed uprising in Kashmir, militancy-related cases, less than 2% had been convicted. So essentially, Public Safety Act and other preventive detention measures, which often have children detained as well, they are often used just to keep people out of circulation and keep pressure built up on the people so that there is no conversation which is free and people do not connect freely on issues that concern them. In conclusion, I'll just say this, that these laws and these policies, they are destroying lives in a most arbitrary manner, the most discretionary manner. And we need to continue to exert pressure by documenting, by emphasizing how these laws and policies prevent the truth from coming out, and to push the state to realizing its obligations towards children in Kashmir. And I really resonated with something that was said earlier in the discussion over here, that this is not unique just in Kashmir or just in Palestine. There are many places in the world that have seen similar forms of oppression, because oppression functions similarly wherever you are. And it's essential for these struggling populations to connect with each other, to learn from each other, because the tools of oppression are consistently shared and openly shared, but the tools of resistance are not shared so openly. And through these discussions where we connect with people from Palestine, we connect with, and we narrate our own story as well, by narrating it ourselves as Kashmiris, as opposed to getting it from other sources. These are the platforms where we can do that. And I thank you all for having executed this, and thank you for having me. If there are any questions, we can take them up later in the Q&A session. Thank you.
Mirza, thank you so much for really shedding so much light on so many details that are often not seen and kind of out of sight. I think that the collection of remarks that have been offered thus far has really provided quite an overview of the complexity of the landscape when it comes to children's rights violations in war, and including where situations of military occupation exist, and of course the added layer of challenges that arise from that. I think we've heard chilling details of how some of these violations manifest themselves, and of course of the distance that exists between the law as it's drafted and then the policy and how it's implemented. We've talked, of course, about legacy of power asymmetries, including the legacy of historical injustices, such as colonial legacies, among others. But I think we've also heard some encouraging perspectives that give hope. I think I always like to look for a positive note in conversations in terms of what the future holds. And I think in particular, Professor Baba has provided a good overview of the various tools that and strategies that we can leverage under international human rights law and various international legal instruments. As well as the possibility of building coalitions and the awareness, how the awareness and advocacy are changing for the better, including to account for children, not just as rights bearers, but also themselves as champions of advocacy. And I think on the heels of this latter point, I wanted to pick up a question that has come from the audience. And I'd like perhaps to direct it to Professor Baba, which is in this context of acknowledging the role of children as champions of advocacy themselves. How do we make sure, or how do we foster avenues for the rights, for the voices of the youngest among those children to be heard? Because oftentimes they're the ones that will have less opportunities or maybe possibilities of coming to the fore with their own concerns.
Yes, Federica, thank you. And thank you very much also to Amar and Mirza for really unbelievably moving and powerful comments. This is an important question. First of all, I'm really pleased that it was raised because the category of child in international law, which spans from 0 to 18, is in a way a very diffuse category. Of course, a toddler or a baby is a very different agent, a very different type of human being from a 17-year-old. And so it's important that we think of commonalities. All these children deserve to have their best interests taken into account. All these children should not be discriminated against. But when we're talking about voice, Article 12 of the Convention, which talks about giving children a voice, when we're talking about giving agency and foregrounding the voice of children themselves, and of course the so-called progressive maturation of the child, the change over time, has to be taken into account. So I agree, it is often very, very young children, and we see this painfully every day, who are exposed to many of the most egregious harms. I just heard 3 days ago of an Afghan woman who we were helping to try to get to safety, and 3 of her children who were assassinated and murdered, and 2 other children with their father have survived. And one can only imagine the trauma and the memories that these young children will have for the rest of their life. So yes, it's very important to acknowledge that very often the survivors of grave human rights violations are very young. And it's also important to recognize, contrary to what people sometimes say, that they can be very reliable witnesses. Just because they're young, it doesn't mean that they exaggerate. It doesn't mean that they're unreliable. And I think we've seen this with Palestinian children, I'm sure with Kashmiri children too. On the other hand, I think we as human rights advocates also have responsibilities to take very seriously the dangers of forcing young children into the limelight as witnesses. There is a danger, there's always a danger of re-traumatization. There are dangers of retaliation. And so these are very difficult calculations. You don't want to exclude a voice that wants to be heard, but you also have a responsibility not to re-traumatize or expose or endanger someone who is already, holding on after terrible odds. And I've had some experiences of this myself, where, you're bringing children to international criminal tribunals, and Omar and Mirza may well have experiences themselves. You're bringing children to be witnesses in international tribunals, but you really have to protect them against retaliation. You really have to ensure their safety in a way which you have to do for everybody, but with children is particularly key. So these are very difficult questions. I don't think there's an easy answer. I certainly don't think one can just say in a simplistic way that every child who has experienced a trauma needs to be, put in front of a microphone or a TV camera. Quite the contrary, I think you have an obligation to think of what's in the best interest of that child. And it'll vary child by child. Some 7-year-olds are remarkably mature, and some 14-year-olds will be extremely timid and unprepared. So that would be my answer.
Thank you, Professor Baba. And of course, you're undoubtedly correct that these are extremely challenging questions, and we can't possibly provide all the answers in just this amount of time. But I think it's important that we do raise the question. So like you, I'm grateful that this particular question was raised, and I'm grateful that your answer highlighted the agency, the need to strike this balance between the child's own agency as well as our ethical obligations and obligations towards a child's well-being. In the spirit maybe of asking another difficult question, which undoubtedly we won't be able to exhaust, but that I think it is important because it touches on something that the ambassador, during the ambassador's remark, was being raised as well. Is it a limitation of international human rights law that it is chiefly intended to states as duty bearers when so much of the violence and violations affecting children in conflict are in fact perpetrated by non-state armed groups? This isn't a question for any specific panelist. I think everybody, each one of you may be free to answer it, but it is, I think, very important to discuss this as part of today's conversation. So if anyone would like to go first.
Maybe I can answer on this. Actually, violation is a violation, whether it's from a non-state actor or from any governmental body. So the international conventions, especially for the human rights, is responsible for answering on these violations, including the Rome Statute, because Rome Statute usually it's sue the perpetrators, individuals. It's not suing states in that manner. So anyone is violating the law, whether the human rights conventions or the international criminal law or international humanitarian law. I think that there's no limitation in that. It's very clear that those who are committing crimes or war crimes or crimes against humanity should be held accountable for these crimes. But the only thing that how to implement these provisions of these conventions, whether human rights conventions or the Rome Statute or the Geneva Conventions or other, there is a responsibility on states to help or to put the mechanism to get these perpetrators accountable. So perpetrators, whether non-state actors or governmental bodies, whether security forces or occupying forces or any of these forces, should get accountable. But as I said, that the limitation is within the mechanisms to implement or to impose the implementation of these laws on these bodies. So we have problem in these mechanisms to bring perpetrators to justice. not whether to identify who is committing the crime, because it's very clear, and there is a lot of conventions that are clearly manifesting that what to do with the criminals, and what are the responsibility of states on international wrongful act. It's very clear, not to render aid, not to recognize, and how to get these people accountable using the local laws, and to improve the laws of the states to bring perpetrators, even if they are out of their jurisdiction, using the universal jurisdiction and other manners to bring perpetrators to justice. I think in the conventions, there is no limitation. In the implementation and the responsibility of states, that's something political. Unfortunately, we can see that the same states, the same country, that they are ready to bring any war criminal to justice, but when it comes to Israel, they silent. They don't want to act. They don't want even to recognize that this is a crime. If any other country, they will put sanctions. They will use the Chapter 7 within the Security Council. They will stop sending them weapons. All of this. There is, as I said, that there is the will also of the international community to implement these conventions, and this is the problem. One of the problems that we all face.
Thank you, Ambassador. I don't know if other panelists wanted to also react to this question. Otherwise, we have another question from the audience, which concerns, and I guess this is a question for the legal practitioners, but it is a do you think that the Committee on the Rights of the Child could operate differently than it currently does, so that it better protects children in conflict?
Maybe, Mirza, go ahead.
I was just going to connect both these two questions about how we see non-state actors as well as state actors, and how the Committee on Protection of the Rights of Child operates in these situations. For the first part, I feel there are two questions there. One is crimes committed by state actors, for which the state has to wholly be held responsible, because these are agencies, these are organs of the state. And in the context of Kashmir, a lot of violence and rights violations that take place happen through state actors, which is the armed forces, the police, the law enforcement agencies. So it's either lapses or active actions on their part which result in rights violations. So that is one part of it. The second part of it is when non-state actors or non-state organs engage in rights violations. And we see this happening quite a lot all over India, where there are multiple forms of violence taking place right now, from lynch mobs that are killing Muslims for having consumed beef, or for accusations, rumors of child abduction, which are spread through WhatsApp and social media groups, and people gather, and there have been many killings that have taken place using these social media networks. But even in that case of non-state actors, the assumption is always that the state has full capacity to govern its area, whatever area is under the control of the state. Because at the end of the day, the monopoly of violence is in the hands of the state. So if the state is unable to control the non-state actors that are within its territory, then it is either allowing them to function in that manner, or it is incapable of stopping them. And in both situations, the onus of responsibility lies on the state. Now, connecting this to the question that has just come up, that how would we see the committee operate differently? I feel that, and again, in the context of Kashmir, India, and Pakistan, it is not enough to leave this for the states to deal themselves. We have now seen 70 years of administration by Pakistan and India, and most of the international community leaves the discourse or this debate between India and Pakistan. Even the United Kingdom, for a long time, depending on which government is in power, but for most of the time, they would say that this is a bilateral dispute between India and Pakistan, and we will encourage them to negotiate it. They're not going to, because if one side does not want to talk, it just results in status quo. So we cannot leave such conflicts just to discourse being conducted by those entities that are themselves perpetrators. They're not going to do it. And therefore, there needs to be greater mechanism of pushing them which can only be through either trade sanctions, which can be through something that hurts the economy or the other institutions, which will not allow them to get away with the crimes that are being committed. Because otherwise we encourage status quo, which doesn't help anyone, and it perpetuates the situation as it has been going on for the last 70 years. So that is perhaps one change that I could see taking place.
Thank you, Mirza. And I don't know if Professor Baba wanted to add anything. Otherwise, yeah, please go ahead.
I could not agree more. I mean, I think this is a very important question. You know, in the kind of drafting of international law, there are different standards for state actors and non-state actors, but actually at the end of the day, the state actors, whether by omission or commission, are ultimately responsible. And so I think the point that the international community has a responsibility to sanction states that fail to uphold their obligations in these ways is a critical one. And I think, you know, Palestine and Kashmir in very different ways illustrate this point very sharply, and other parts of India, you know, Assam, and, you know, and there are many areas in which, you know, the kind of fig leaf of democracy is abused to actually violate and enable violation of rights by people who, non-state actors, but who may have very close links to agents of the state. So it's often not that clear a distinction, actually. So anyway, I really very much agree with the points that were just made.
Thank you. I see that there are a lot of questions coming from the audience, but we are right at time. We have 2 minutes left, and I think I would like to turn back to the convener of today's discussion, Professor Leon Feinstein. But before I do that, I really wanted to thank personally all three of our speakers for their extremely insightful and thought-provoking remarks. So thank you so much for being with us. And Leon, floor is all yours.
Thanks very much, Federica. I wonder if I could ask for 30-second answers on a final question. I don't know if it's possible, but my final question is whether you think, in relation to the struggles in Palestine and Kashmir, the UNCRC as an institution has made a positive difference. I wonder if you might each take just 30 seconds on that question, and then we'll close. Thank you. And I guess I'm chairing now, so why don't we come in reverse order? So Mirza first, and then Ambassador Wadala, and then Jackie, please. Thank you. You're muted, Mirza.
So that question was can I start, or
go ahead, I will.
Yes, okay, thank you. I think it's positively contributed because you know, in 2004 there is an advisory opinion by the International Court of Justice came out with a decision that Israel should implement the human rights conventions on Palestine, and one of them was the CRC itself. And after that, the CRC started to report on the situation of children in the occupied Palestinian territory, and they came out with very good concluding remarks, and also remarks not only to the Palestinian side, but also to Israel, asking the Israelis to give the Palestinian children their rights in education, in right to life, and right all other rights within the human rights conventions. So the convention and the treaty body of the CRC itself, they came with very good concluding remarks about the applicability of the international human rights law and the international humanitarian law on the Palestinian people, which bring back the status of the Palestinian people within the occupied Palestinian territory as people that under a brutal illegal occupation. I think they have a very big and good contribution, not only in accordance with the Israeli occupying power. Now we are a state party to the same convention, and now they are sending recommendation to the state of Palestine also to implement it, to protect the future of the Palestinian people, to protect the rights of the children.
Ambassador, thank you very much. That's a very encouraging answer. Mirza, I don't know if you can get your sound back on. Give you 30 seconds on this question if you can.
Sorry, can you hear me?
Go ahead.
Yeah,
Yes.
sorry, could you just repeat the question? I was answering a question in the comment section.
My question to you is just very briefly, 30 seconds, whether the UNCRC as an institution has provided positive support in the struggle that you have described.
Well, it's not sufficiently provided support in the struggle in Kashmir. And like we said, that number one, there isn't enough documentation that takes place from our side. This is because of suppression on the internet, suppression on journalists, suppression on data collection. And where there is collection of data also, there are the people who conduct in that collection face tremendous reprisal by the government. Right now, we have various journalists who have been detained for writing against the government or even highlighting the facts of what is taking place on ground. So the committee is not, while on one hand, is not able to collect data from the ground, on the other hand, is unable to protect the people who are collecting that data and getting that information out. So unless these two steps are taken forward, we will face hurdles continuously. It's only
Thank you. Sorry to cut across you. I just conscious of time. That's a very helpful answer. Jackie, I'm going to give you a final word on this question if you want to.
I'm just going to take my prerogative of professor and suggest a book by a political scientist called Beth Simmons, and it's called Mobilizing for Rights, or Mobilizing for Human Rights. And for anybody who wants to understand how to analyze whether a convention or any international law practice made a difference or not, it's a fascinating study. And she has a whole chapter on the CRC and has it made a difference or not, looking at the data. So I recommend that.
That's a fabulous and academic answer. Thank you very much. Entirely appropriate. Thank you all. I'm sorry we've run out of time. We've only scratched the surface of this huge and important set of issues, but thank you all hugely for your participation and your inspiring words today. Particularly thanks, Federica, for chairing, and to you all as speakers. Thanks again to WIAM for organizing with Nika and Manoli, and Joanne in the comms team, without whom none of us would be here. Apologies to cut things short, just to say we'll be back on next week again at the same time, talking about what is a child, the question of what is a child. And I hope we'll have another excellent lineup, and I hope colleagues will join us again next week. We will try and do a write-up of this, and we'll be in touch, speakers, with and share with thoughts about that if you're interested in participating further in the discussion here. So just finally, thanks everyone for joining today. Wonderful debate, and thank you very much to our speakers. Thank you.
Thank you very much.
Thank you, Omar. It was wonderful to hear you. I feel we can only make so much progress in the seminar room in Oxford, but it's very useful for us to hear your perspective and your insight, and who knows what the students will be able to do with that over time.
Thank you, everyone, for a great discussion.
Thank you for bringing us together. Bye-bye.
Bye.
Thanks all. Thank you.